Welcome to Trust Us, Estate Planning Wisdom, the podcast where we unravel the complexities of estates and trusts to empower you with the knowledge needed for effective estate planning.
This podcast is hosted by seasoned estates and trust attorneys, Danielle Friedman, Fineburg, and Charles Max McCauley.
This podcast is your guide to the intricate landscapes of estate planning, including wills, trusts, and probate.
Thank you for joining us, and we hope you find the discussion informative. But remember, when it comes to legal matters, always consult with a qualified attorney regarding your specific case.
Hello, Max and Danielle. We're here with another question to answer for a client. In this situation, we're going to address what happens when your spouse has died and you don't know where the money is or what bills need to be paid. In addition, there's a whole lot of other issues that need to come up that need to be addressed by the surviving spouse and maybe the surviving spouse and an attorney. What would be the first thing that you would do, Danielle, after your spouse dies besides the funeral?
Of course. And the first thing I would say is there's nothing that is an emergency. Take the time to grieve, take the time to be with family. Of course, the death of a spouse is a terrible loss. And if it takes you a month, 2 months to kind of get the wherewithal to start dealing with all this stuff, then that's okay. Don't let the stress of financial decisions and estate administration and things like that stress you out in an otherwise already difficult time that you're having. But if we're going to start talking about housekeeping, starting with the funeral and then taking a break is a good kind of way to get into this, because with the funeral, what you want to make sure is that there is no prepaid funeral, or maybe there is a prepaid funeral, and just making sure that you're taking advantage of any funeral planning that was done during your spouse's lifetime. Most likely, you probably also have a similar type of arrangement, so you'll know whether there's a prepaid funeral arrangement or not. But I would say handle that, handle the funeral. And then when you are ready to start dealing with more financial matters, I think the first phone call you should make is to competent estate counsel who can handle and help you walk through the estate administration, trust administration process. And the second phone call you should make would be to the accountant. The accountant has a really good background of what the assets might be, what tax obligations there might be. And let's assume you are a spouse who is completely in the dark about what your spouse owned. These are the first two people I would call.
So the Form 1040 might have some information. Max, what do you think you would discover on a Form 1040 if you called up your accountant?
Sure. If you had or your spouse had investments of brokerage accounts and the like that either issued K1s or 1099s, those are most likely going to be found on your return, or the 1099s would be saved with them, but your accountant would have a copy of them because he used them to prepare your returns. So it's a good insight on where your assets are. Likewise, review your mail for a year. You might find assets that you didn't know existed that weren't on the tax return for some reason, but you'll be notified in the course of a year from the date of death of what kinds of annual mailings might come in, such as premium notices for life insurance that you might not have known existed.
And I think that with talking to the accountant, the 1040 is going to list anything that generates reportable income. So if an asset generates income, it's going to be on the 1040. Maybe real estate, like residential real estate, might not be on there if it's not generating income and you're not depreciating it or something like that. But generally speaking, it's a really good place to start. I would look at the last 3 years of income tax returns that were filed, and your accountant can walk you through it. The other thing about hiring competent counsel is that they're going to be able to tell you what questions to ask, right? You don't know what you don't know. And so by hiring a competent estate planning attorney, you're going to be working with the attorney, often with a paralegal who specializes in administering estates and trusts. And they're going to know what questions to ask because they've seen so many different types of estates, different levels of assets, different categories of assets, where to look for this type of stuff. So there are experts in this. This doesn't have to be all on the surviving spouse's shoulders.
So you go to the funeral home. What's the most important thing that the funeral director gives you?
The death certificate. And I can't tell you the number of times that the death certificate that we get has errors in it. So make sure that the death certificate has accurate information. Specifically, you might not know that one state has an inheritance tax and another state doesn't have an inheritance tax. But if you and your spouse split your time between Pennsylvania and Florida, but your spouse was a Florida resident but died in Pennsylvania or any other state, make sure that the death certificate has the right state of residence on there. But that's the biggest error that we see, because that's going to determine whether taxes are due at death. Pennsylvania has an inheritance tax, Florida doesn't. So if your spouse was a resident of Florida but died in Pennsylvania, make sure that the funeral director doesn't put Pennsylvania on the death certificate.
What happens if they do put the wrong address because you're under stress and your spouse is a Florida resident and they put down your apartment in Philadelphia? What do you do?
So you can ask the funeral director to make a correction. One, that may take a lot of time. Two, they may need more than just your word. They may say, no, we need a court order, we need X, Y, Z. So it really depends on sort of the relationship with the funeral director. They obviously can't commit fraud. You want to give them accurate information from the outset, but you can get a corrected death certificate. Again, it just prolongs the process a little bit. Sometimes it takes time. They have to get approval, maybe from the Department of Health or another regulatory agency, to correct the death certificate. So getting that accurate information the first time is important, but certainly mistakes happen when we're under a lot of stress.
And they'll get 10 copies of the death certificate.
Yes, get 10 copies, because your bank is going to need one. If you have to go through probate, the court is going to need one. If there's life insurance, the life insurance company is going to need one. So start with 10. You can always order more, but start with 10 because you're going to need original death certificates.
Just as a side note, I found that in a situation where the resident, the decedent, was a Florida resident, if you're able to give the funeral director a current driver's license, they'll accept that as the evidence of residency and submit that to the state, which is a nice way to handle proof of residency.
Absolutely.
Social Security. Who gets checks? When do the checks stop? Can you get anything additional from Social Security?
I can give you some thoughts, including when you're dealing with the funeral home. A lot of times the funeral director will report the death to Social Security for you. But if they have not, then you'll want to make sure that you do that. And you cannot inform Social Security of the death online or by email. You either have to call or visit your local Social Security office in person. As for the month of benefits that your spouse died in, so if your spouse died in March, the payment received in April, which pays for March, would have to be returned to Social Security. If it was direct deposited, notify your bank so your bank can return the funds. Don't spend the funds. You're not entitled to them after your spouse dies. On the other hand, if you're also collecting Social Security, do not cancel your own Social Security benefits. If your spouse's Social Security benefit was higher than yours, you may be eligible for your spouse's benefits. Sometimes the Social Security Administration knows this and will automatically switch you, but don't assume that's going to happen. If your spouse's benefits are higher than yours, you can apply for your spouse's benefits. Also, there's a one-time $255 death benefit paid by Social Security. That's if you were living with your spouse at the time of death, or you're already eligible for your spouse's benefits on their record. But it's not automatic. You must claim it. So what do you need if you're going to call Social Security? You need your spouse's name, full legal name, Social Security number, date of birth, date of death, and your information as a surviving spouse.
So if your spouse dies and he or she is working, is there anything that you would call that employer about?
Yeah, so I would call the employer and see if there's any death benefit associated with the employment. A lot of employers have automatic life insurance policies on the employer's lives. Certainly any qualified retirement accounts, 401k, deferred compensation with non-qualified accounts, any pension or death benefit associated with a pension. Also, if your spouse is a veteran, I would call the VA and see if there's any benefits there. Sometimes they offer funeral assistance or some form of death benefit. Call your employer, call Social Security, call the VA. And then again, if you hire competent counsel, they can help you with this too. Part of what my paralegal does is help clients marshal the assets of the decedent and sort of inventory everything, collect everything. And yes, you're paying a fee, but it can save you a lot of time and grief. It can be difficult to call these places and constantly have to revisit your spouse's date of death and all these other facts that a third party can handle for you, can call, can claim benefits for you, can at least get the forms that are needed to be completed so that you don't have to do this on your own. I think that's the biggest takeaway, is that you don't have to do this alone if you get competent help.
So there's group life insurance, what you just suggested. You call the employer, find out what group coverage they had and who the beneficiaries are. If there's private life insurance, that would typically be evidenced by a policy. How do you find out about that?
I think you could maybe see where, if you look back at the bank statements, where premiums are being paid from. If there's a financial advisor, certainly they may know. If there's life insurance, talk to the attorneys, because there might be a life insurance trust, or the attorneys just might be aware of a life insurance policy. Who knows? Maybe it expired, but at least you can call the insurance company and confirm as to whether the policy existed and claim the death benefit. They're going to need a death certificate. You're also going to want to ask for a Form 712, which is a tax form that the insurance company gives, that most likely your attorney is going to need when they file any sort of death tax returns.
So Danielle suggested that we look at the bank statements or the bank register, your checkbook. Sometimes it's online, but what else would the past checks that are written tell you that may not be revealed in looking at the income tax returns, Max?
Well, before we jump to that, let's stick with the employer for a second. If you were covered by your spouse's health insurance and or your children or dependents were as well, then you would be eligible for continuing medical coverage at your cost under COBRA for up to 3 years, 36 months.
Excellent point. That's very important.
And it's not automatic. If you don't pay for the premiums, you won't have insurance coverage. So you'll want to contact your employer, let them know of the death. They should automatically send you a COBRA notice in a week or two. And then you'll have to follow that with either on your own or with assistance of counsel to claim the coverage and make the payments.
So that's something that's more urgent than most other things. Mortgage payments might be urgent, but COBRA, when you get a notice, gives you 30 days to elect to keep COBRA coverage. And with that, you're required to file the election with the employer and pay the premium, typically the premium plus 5% to the employer, and you'll get that continued COBRA coverage. And you have to pay the full premium, even though before your spouse passed away, the employer might have been paying part of the premium for health insurance.
Back to your question, what else might the tax return show?
The tax checkbook.
I would say look at the deposits. If you were receiving, and again, your tax returns might be helpful for this, but there might be regular deposits either annually or monthly that are sources of revenue that may or may not be on the tax return.
How about expenses on the bank statement? But does that tell you what you have to pay?
Certainly, it would give you a hint, especially if it was on auto pay or otherwise, or ACH draws, the utilities that might be due, premiums, say for car insurance or homeowners insurance that may be due, anything that could be on a recurring cycle that you might not get a bill today. A lot of times you can set yourself up for paperless billing. And so if you do that, you're either going to need the passwords, the online login information. And if you don't have that, well, look at the ACH debits that are coming out of the account and to determine what they were for. It might be online bill pay that's automatic for utilities or, again, premiums, mortgage payments, car payments.
Passwords are another important topic. So that could be for getting into your spouse's email so you can see what's going on as far as bank bills, because the bills will come into the email. As you said, getting into bank accounts, getting into any number of accounts and addressing that spouse's Facebook account by way of example.
Exactly. I've known spouses that cherish the photographs that recur, but they didn't have access to the social media password for their spouse. And so that was a long, difficult process. But I think it's a process that can help you grieve if you have access to your spouse's Facebook or Instagram social media accounts so that you can review those posts that come up or even notify friends and family of the death.
A lot of these custodians of this information, whether it's Google or Facebook, allow you to set someone else as the recipient of your passwords and information when you die. It's in the settings of your Gmail or your Facebook or your Instagram, Apple, whatever it is. And you can go in there and say, okay, if someone requests access to my data and I don't deny it within 36 hours or however many hours, here's the email address for my spouse. Here's who can have access to it. So you can do that. There's also in your will, there should be something that talks about access to digital assets. So, call up Google and say, my spouse died. I need access to their email. They're not going to automatically give you access to their email. They're going to want to see some sort of proof that you are either the executor or a trustee or something else. And so that's often in the will. You may even need to go through probate to get access to those assets. The better alternative, I think, is preparing some form of digital asset instruction letter. While you're alive, you and your spouse should have somewhere secure to save passwords, or maybe they use an online password manager and they give you access to that.
Or at minimum, access to your spouse's phone, because your phone will have potentially saved passwords.
Exactly. Something to get access, because so much of our lives is digital. I think that's very important. Your spouse may even want to leave instructions for, do I want my Facebook account maintained or do I want it deleted? Do I want my Instagram account maintained or deleted? All these types of things. In their will, they might say, yes, you can access my Gmail, but you don't get access to the contents of the email. You can only get access to a register of the emails. So there's a lot of room for what kind of access you can gain to digital assets. And it can be overwhelming at times. Again, with the right counsel, I think we can sort of narrow the priorities of where you need access to: the bank, probably the email, social media, if you can get it.
And I do think counsel can help you focus on what needs to be done immediately and what can wait.
We can also do things like, I have petitioned Apple before to grant access to a spouse that they didn't want to grant access to, and getting orders from judges to unlock phones and things like that if you really don't have your spouse's password to their phone. If you're really in the dark, there are ways to gain access to information, but hopefully it's something as simple as your spouse kept a password manager and you just have access to that.
And key will be to have that death certificate.
Yes, death certificate is always needed. And usually, just to go back to the death certificates, they're usually issued within a few days after the funeral. I've seen it as long as 2 weeks, sometimes as quick as 3 days, but I would say on average, it's about 10 days after the funeral is when you're going to get your death certificates.
Going back to this topic of getting a judge's order, one of the biggest things that people always talk about when a spouse dies or a relative dies is the process of probate, which can be very slow, very upsetting to beneficiaries and relatives who can't put up with the pace at which a court might proceed. Is there a way to avoid the whole probate process?
Sure. Especially with spouses, there's 3 primary ways you can avoid probate. One is through joint ownership. So spouses frequently will have joint bank accounts or own real estate jointly. And if one spouse dies, the surviving spouse usually inherits that property outright. That comes with its own estate planning problems. But if we're going to just stick to focusing on probate, that does avoid probate. Beneficiary designations. So if you have assets with beneficiary designations, frequently IRAs, 401ks, life insurance policies are going to pass that way. Anything that has a beneficiary designation, unless it's designating the estate, it's going to avoid probate. And then last but not least is if an asset is owned by a revocable trust or an irrevocable trust, it's going to avoid probate. So if an asset is in a trust at the decedent's death, it's going to pass automatically pursuant to the terms of the trust. It doesn't have to go through probate. Probate is the last resort for everything else that doesn't fall into the categories I just mentioned. So you could have an estate where some assets go through probate, some don't. That's pretty common. Or you can avoid probate entirely and save that time, expense, and headache. But it's important to have the planning done ahead of time so that your trust is funded the right way, your beneficiary designations are updated, your joint assets, if there are any, are properly titled. So that takes some planning to avoid probate.
So if an asset is in the decedent's name alone, you're going to be stuck in probate. And the solution that you just mentioned is you can retitle that asset into the name of that person's revocable trust.
Yes. And a lot of times, let's say I know they're dying. Shouldn't my spouse just retitle that asset into my name while they're alive? And my answer for that is no, because then you lose some significant income tax advantages if you do that. There's a lot of other planning at play, but I don't want to muddy the waters too much for today's conversation. I really want to focus on what the surviving spouse should do immediately after death. And yes, eventually figuring out how assets are titled and determining whether you have to go through probate is something, again, that your attorney can help you with and certainly help you go through the probate process, file the paperwork that needs to be filed, follow all the administrative requirements that must be filed, notifying beneficiaries, notifying creditors, and all of that. And then speaking of creditors, a lot of spouses start to panic when they see bills come in, credit card bills, medical bills, other debts that they knew or didn't know existed. And their instinct is to pay those immediately.
And they can come in the mail, email. It's what you need to get the password to see the email.
I would say you don't have to pay all the bills right away. Sure, make your mortgage payments, make your car payments, pay your insurance costs and premiums. But credit card bills and medical bills and things like that, those can wait because we want to make sure that there are enough assets to cover all those bills. I mean, hopefully, yes, but sometimes you may have an estate where if everything is joint and automatically passes to the surviving spouse at death, but all the debts were just in the deceased spouse's name, you may technically have an insolvent estate where you don't need to pay those debts. Again, talk to counsel, but there are certain debts that nothing is going to happen to you if you wait 30 days, 60 days to make a payment. Maybe you'll get a letter from a collection agency, but the letter is scarier than it looks.
Wow. There's a lot to do, a lot to think about. And I think we covered almost every topic. We can separately cover, as you said, Danielle, issues with federal estate tax or state inheritance tax in a separate podcast. But I think, Max, you and Danielle covered every topic. Did I miss anything?
No, I mean, there are certain tax considerations and elections and things like that that you do have to make in a timely manner. But I think the focus of today is really to focus on what are the immediate top of mind things that most spouses need to deal with. There's things like disclaimers and funding trusts and things like that all go with estate administration, gifts to beneficiaries and things like that all come a little bit later and will be covered by competent counsel.
Great. Thanks again for all your great advice, Max, Danielle, and this Herb Fineburg. And we'll look forward to our next podcast.
Thanks, Herb.
Thanks, Herb. Thanks, Danielle.